All right, here we are, hopefully without transition difficulties, and I'll do my best to pick this up exactly where we left off in the last video. So, as I say, you should be aware of the way in which, in the end, litigation is between two parties, and judges or justices, in the end, have to decide for one or another party. And when you have a panel of judges or justices, which you do in certain appellate contexts, as to which party should prevail, disagree as to the principle or the legal theory, as we say, explaining why. And sometimes are very small and they coexist with very large areas of principal agreement. But in some cases, the Smith case is one of them. I think the Seattle Schools affirmative action case is another. You get agreement consistent with tremendous disagreement over the principle. And in the Smith case and in some other cases, it seems that the dissent and some of those in the holding actually agree about a far deeper matter of legal principle. That's, I think, arguably what is going on in the Smith case. So while there are conservative justices who join with Scalia in holding for the state, in holding that the law is not unconstitutional. Those conservative justices and the liberals who disagree, finding it is unconstitutional, both do agree that the law should have been subjected to strict scrutiny. May be tempted to go into the law as a mechanism of social change and reform. Not legislation. It's not, in fact, a place where matters of principle always get kind of straightforward up and down assessment. It's a litigation between parties, and agreement as to which party should prevail can coexist with very deep disagreement as to what the right legal theory appropriate to the facts at hand is. This is just a deep fact about law. When you think about it, it's obvious. It's true of any competition or award system. It's true as to how it is that somebody gets the gold in figure skating in Olympics. It's not something we're utterly unfamiliar with. But I think when you fully grasp the implications of this fact, it ought to affect how you think of law as a mechanism of social change. It obviously means it is or may be a deeply imperfect one in certain cases. And as I say, this fact will matter to some degree or other throughout this course, depending on the kind of case we're looking at. Here, it's very striking, since Scalia gets a remarkable sea change in how religious free exercise is seen in the Smith case. So Scalia argues that not the Oregon law is constitutional because it passes strict scrutiny. Scalia believes the Oregon law does not need to be subjected to strict scrutiny in the first place. This is so remarkable, even Congress noticed and did something about Scalia's decision, which we'll get to in a moment. But you may have figured it out for yourself if you read the Wikipedia entry on the Hobby Lobby case, which I sent you. So I'm going to call generally a policy argument, why it would really be better not to subject the Oregon law to strict scrutiny. But of course, since this is the Supreme Court and they're not simply offering justifications for the best policy, but enacting what they believe to be pre-existing law and constitutional requirements, Scalia also has an argument as to why it is that if you really look at precedent closely, or with my special Scalia analytic glasses, it turns out you don't really apply strict scrutiny in a case like this in the first place. This is a wild argument. I don't think it's very good. There are some parts of it that aren't awful. I'm actually sort of sympathetic to, but the main thrust of that argument is, I think, extremely dubious slash suspicious, not obviously very good. The policy argument is not a bad argument, as I think most liberals who excoriated Scalia after the Smith case have come to agree after the Hobby Lobby case. And I'll make that point as time goes on. All right. The policy argument, as you see, is that, look, Scalia says, we can't subject any otherwise, I think the language is neutral, generally applicable law, a law that is clearly not aimed at any particular religious group. That's what he means by neutral, generally applicable. There's no inherent bias or singling out of a particular religious group in the nature of the law's content. It is a neutral law. It says, neutral law to strict scrutiny. Lots of perfectly good laws will fail. He's certainly right about that. Yoder's a very good illustration. I mean, there's nothing really wrong with the Wisconsin law at stake in Yoder, but it fails strict scrutiny. Strict scrutiny, as you will see again in the Hobby Lobby case, demanding test. If it's interpreted by a sufficiently aggressive judge, it's hard, because all you have to be able to think, all you have to manage to achieve in order to show that a law fails the test of strict scrutiny is to imagine how the state could achieve its legitimate purpose consistent with allowing an exemption in this case. If you've got a good imagination and you understand the word could in a sufficiently open textured way, a lot of laws will fail strict scrutiny tests. You say, well, couldn't we give this exemption and still do what the state wants to do? I mean, if you understand could to mean something like, is it logically possible that, or empirically possible, then yeah, a lot of laws will fail the test of strict scrutiny. And as Scalia says, and I love this line, says, for every law that forbids X or requires Y, there'll be some religion that forbids X or requires Y. I got this right. For every law that requires X or forbids Y, there'll be a law that forbids X or requires. So I think I'm continuing to get it wrong, but you see the point. Any law that has you requires you to do something or forbids you from doing something else can be matched against the religion that forbids you to do that and requires you to do that something else. There's always a religion out there. This is Scalia's point. We have a million religions with a million beliefs. And as the court, we're not going to assess how central these beliefs are. If it's a belief in that religion, respect for religious free exercise requires we treat it on a par with any other belief within that religion. We're not going to try and separate out the really central beliefs, like, well, obviously, belief in the Trinity is very important to Christianity, whereas perhaps some other beliefs aren't so important to Christianity. We're not going to do that. We're not theology professors. We're going to assume here, from the standpoint of law, that any religiously motivated conduct is on a par with any other. And if all it takes for a law to be, if all it takes for a law to trigger strict scrutiny is that it brushes up against religiously motivated conduct, all kinds of good laws will suddenly be subjected to this extremely demanding test and fail. This approach, Scalia says, courts anarchy. It makes every individual, what is it? A private right of disobedience is granted to any individual in virtue of their religious beliefs. So Scalia feels surely, in the absence of other considerations, merely a kind of opposition between the content of the religiously motivated conduct and the content of the law can't be enough to trigger strict scrutiny. It's just too unstable and volatile a theory of political stability. I mean, it's a theory of legal interpretation that in turn generates a wildly unstable political outcome. If we really were committed to subjecting every law that conflicted with religiously motivated conduct to the test of strict scrutiny, it seems obvious to Scalia we would have an infinitely more unstable political community than we reasonably want, that we presently have, and so forth. But then you might say, but wait a moment, you're just the Supreme Court justice. You can't worry about the appeal or the lack of appeal about certain outcomes. That's not your job. You have to ask, does the law require? How can you say that we don't have to, that's how I should put it, or we shouldn't apply strict scrutiny to the Oregon law when we did so in the Sherbert case and we did so in the Yoder case? Here's the legal argument. Aha, Scalia says. The Sherbert case, that's just a case about insurance excuses. Of course, there's going to be strict scrutiny to a list of excuses that the state offers if it fails to include reference to religious belief. The state would have to have a very good reason to exclude some particular religious groups, religiously. This is not what he would call a generally applicable law. This is, how can I put it? This is just a regulation. This isn't something with the imprimatur of a democratic outcome, like, the kinds of laws we have coming out of Albany that say what the penalties for, involuntary homicide are and what the penalties for selling a certain amount of heroin might be, and so forth and so on. This is just a government regulation in which a list of excuses in virtue of which one is entitled to refuse work are enumerated. And obviously, if the state leaves out whatever it is that your particular religious doctrine holds regarding when your Sabbath is, you got to ask yourself, what the hell? You got to have a very good reason. We're going to look very closely at this law. I'm actually very sympathetic to that point, that what's going on in Sherbert is not on a par with what's going on in Yoder or Smith, where you really do have a general, neutral law applicable to all citizens under all circumstances. And Scalia wants to say, sure, it's fine to apply strict scrutiny to an unemployment insurance compensation regulations list of excuses. That's not the same as what's going on here. You might say, okay, fine, maybe we can set this aside for a later, closer discussion if you like. But what about Yoder? What about Yoder? That's a neutral law, and we applied strict scrutiny. Aha, Scalia says yes, but there was a second constitutional right as well. This is the famous hybrid claim, where he says it's never the case that a religious free exercise claim on its own will warrant strict scrutiny. In the Yoder case, there was also the parents' constantly protected right to oversee the content of their children's education. So there were two constitutional rights in play here. That's why strict scrutiny was triggered. If it had merely been a claim of religious free exercise, no strict scrutiny. It's not enough. That you might remember in that passage where he says, even if we were inclined to breathe some life into the Sherbert test, that's what he calls the strict scrutiny test, the Sherbert test in that passage, it wouldn't matter, because what has to be in place for strict scrutiny is, in addition to a free exercise right claim being made, a further constitutional right claim is being made. Now, this is the argument that makes people like me, and there are many people like me on this one, as we just don't know what to say. It seems so obviously a lousy argument. First of all, there's nothing in the Yoder case that suggests that the parents' right to oversee the content of their children's education has a role in the court's application of strict scrutiny to the Wisconsin law. That's one point. But here's another point I'm very fond of making when this comes up. the rights and the claims generally that you make in a legal case, there's a lot of plasticity here. It's not like these are some empirical facts like, the width of the Grand Canyon or something that you can just undeniably detect and then represent. I, in the case, for example, the Native Americans, if they had known this argument of Scalia's was coming, or if this had been received doctrine, they could have easily tacked on a freedom of association claim as well. They could have said, well, by denying us the freedom to ingest peyote in sacred ceremonies without criminal penalty, you're also impugning our right to association, not just religious free exercise, but our right to associate in voluntary associations in an unhampered and unhindered way. It would have been a very credible thing to say. The number of claims that you make in a legal, proceeding is often wildly fluid, very flexible. In a former life, when I was myself kind of working as a lawyer, never really very well at it, but I was involved in a case where the firm I was working for were defending these recycled plastic salesmen. These were people who bought up large amounts of unused plastic, the kind of plastic you'd have, say, in a subway car, all that seating, or anything like that, any large scale production of plastic, which for whatever reason has now become obsolete. And then this stuff is shipped to certain factories where it's melted down and repurposed to other things. It's a very lucrative world. These guys were working for a particular firm, and then they left to be in business for themselves. And there's a typical kind of litigation that the guys who left were using the contacts that they had made while working for this earlier employer, and the earlier employer is claiming that's my property. They're not allowed to do that. They're, of course, claiming this is part of their freedom as workers. As a matter of fact, in the state of New York, courts are extremely protective of your right to work, and there's the employer, the former employer, had a bit of a steep hill to climb to try and get the court to prevent these people from calling up people they used to know and say, hey, we're in business for ourselves now, and here's what we can sell you. And indeed, that's how it came down. But it was very fiercely contested, and everybody had very good legal representation. And as is often the case in these kinds of cases, these guys, they had this big fancy firm to, handle some of the big federal claims. And they also had this really local guy out on Long Island to handle some of the more, what can I call it? Just contentious state-based claims. And this guy, like a lot of his ilk, had a nice freewheeling attitude about how to argue his case. We're having a conference call about what the claims might be. And he was actually saying, and I think we should add a 14th Amendment claim. 13th and 14th Amendment claim, because if they're not allowed to call these people up and make the offers they want to make, it's like an involuntary servitude. About, you're kidding, right? You're really going to argue that these two guys might be told by a court you can't call up the people you used to do business with because that's violating a kind of property right? This is like involuntary servitude? You really want to say this? It just seems so nuts to me. But the point is, why not say it? Make the claim. The court can say, we don't find it, but it just goes to this point that Scalia is making, as if it's so, crystalline and objective and undeniable what the claims in the case might be. Now I'll go back to the earlier point. Surely the Native Americans could have added another claim if that's all it would have taken to get the strict scrutiny triggered. As I say, they could have added freedom of association, perhaps even freedom of speech. I don't know, because now we can't really speak about ingesting peyote without criminal penalty. I don't find that a particularly plausible addendum, but you see my point. It's such a wild thing for Scalia to hang his argument on that you'd need a second claim, when the number of claims that you can make in cases like this is often just a matter of what the lawyer decides. It's not as if the facts rigidly, I guess that's the word I want, determine exactly what the claims will be. So this argument strikes me as terribly bogus, and I don't think there's any case and lots of other cases to suggest that unless there's a second claim, the court won't be motivated to apply strict scrutiny. And needless to say, the majority of the court doesn't agree with this claim. The majority of the court doesn't, but enough concur with Scalia's holding that the state wins that Scalia's holding is the holding of the case. Why do the others think as they do? Well, I went through this a bit in the earlier presentation. You could very reasonably think that Oregon will pass strict scrutiny because when it's drug use stuff, if the state wants to make it illegal for anybody, whatever their reason might be to use this substance, they can do it. They've got if they're interested in the health, the welfare of their citizens, they might want to prevent somebody, somebody could be close to very serious self-damage and they're going to stop him from doing it, even if his reasons are religiously motivated. You might not like it, but the state could say, if this is a legitimate purpose, and we really can't carve out an exemption because our purpose is to protect all our citizens regardless of their motivation. It's analogous to what I said about Yoder. If we understand the state's purpose in the Yoder cases to make sure every child has the opportunity to choose for themselves, then obviously nobody can be exempted from this law. So you could think that, sure, subject the state to strict scrutiny, subject the law to strict scrutiny. The state will still win because they have a legitimate purpose that's never disputed. The Native Americans hardly dispute that the state doesn't have a legitimate purpose. They're just arguing the most narrowly tailored means aspect of the test should prompt a religious exemption. But the state could characterize its purpose in such a way, if it's all about the health of its citizens, to require the conclusion that there can be no exemption. Conversely, the liberals in this case say, first of all, you have to apply strict scrutiny. I don't know, there's some very appropriately skeptical and sarcastic language in the dissent where Scalia gets the idea that if it's a neutral, generally applicable law, it doesn't get subjected to strict scrutiny. This is exactly what respect for religious free exercise requires, that laws like this do get subjected to strict scrutiny. But like I say, the majority justices agree with that. Those who think that were the Oregon law subjected to strict scrutiny, it would fail, point to a variety of considerations. One of them is the state obviously doesn't really have a serious interest in enforcing this law against Native Americans, executing them for violating the law. And it apparently doesn't. That's one consideration. The other is pretty obvious that, unless we characterize the state's purpose in a highly charitable way, a way quite favorable to the state, it seems undeniable that states can carve out this religious exemption and just still achieve the general purposes that such anti-drug use laws have. So we'll never know what would have happened had the Oregon law been subjected to strict scrutiny. There really are good arguments on both sides. They're right there in the case, both those who side with Scalia and those who don't make those arguments. They're both, I think like the Yoder case, this is one of these things where, depending on the quality of the litigation, to how the lawyers argue it, how the back and forth goes in the oral argument, who's on the bench. I could really see this case having, both of these outcomes were litigated twice, just like the Yoder case. You imagine this fact pattern replicating itself in several contexts, and you could easily see how the decision could go either way, and did go either way. We'll see this in the Zellman case. By the time it gets to the Supreme Court, every lower court has done the opposite on very close decisions, 5-4, 3-2 kinds of decisions, where one court says, yes, this program is permissible. Another one says, no, it's not. It's no surprise. The arguments really are very good on both sides. So these are hopelessly tough cases. I don't think that's a problem. I mean, from the standpoint of Supreme Court jurisprudence, you would just say, look, and that's what I think it could be. Ginsburg, who says this, I don't remember. This is what respect for religious free exercise requires. The messiness of looking at these laws, doing our best to figure it out in a case-by-case basis. But surely the religiously motivated plaintiff does get to have strict scrutiny applied to the law. Otherwise, what's the commitment to religious freedom amounting to? And if these laws aren't going to be subjected to any kind of exacting test once they require or forbid what the person's religion forbids or requires. I'm pretty sure I got it right that time. And I think that's pretty undeniable. If the law requires what the religion forbids or forbids what the religion requires, you would think respect for the religious belief requires that the law be looked at closely and be forced to show that it has a legitimate purpose, that it's pursuing by the most narrowly tailored means. And Scalia, in the Smith case, throws this out with this mix of what I'm calling suspicious legal and reasonable policy arguments. Okay, now what? Well, it's very rare in this course that I actually speak about actual legislation. But subsequent to the Smith case, Congress goes nuts. And they think, I can't believe it. What? No strict scrutiny when religiously motivated conduct brushes up against the law? So they pass legislation, the Religious Freedom Restoration Act. In federal cases, the court must apply strict scrutiny. None of this, and that's fine. And subsequent cases, Scalia is happy. Look, if Congress speaks, and this is what Congress tells me to do, this is what we're going to do. And this brings us to the Hobby Lobby case. When we're in the Hobby Lobby case, the Affordable Care Act is subjected, or this provision of it is subjected to strict scrutiny. And I'll get to that in just a moment. But parenthetically, I just want to say, when these cases go down, and there was a recent one just a few months ago under, the Trump administration, in which I think very similar to the Hobby Lobby, employers were resisting complying with certain features of the healthcare insurance. Inevitably, they have to do with birth control. I have not read this case yet. I don't think it's published in the abridged form that I wait for yet. It will be. It's not important. The Hobby Lobby case is sufficient for our purposes. My only point is there's often a lot of criticism of the Supreme Court when it finds for these plaintiffs to be excused on religious grounds from complying with progressively motivated legislation. It's not the court's fault. It's the law that Congress has passed that requires the court to ask this extremely demanding question. Is there some other way to get this outcome without making this guy do what he doesn't want to do on religious grounds? It's not the court's fault. That's just not. And in this country where we hive off so much of our social policy on private actors, it's just a nightmare of this kind. I mean, all right, let's go to the Hobby Lobby case, and then I'll continue with my rant when that's done. But, I'm sure you know where I'm going. Look, the government, if you had, direct government provision of healthcare services, and the government simply sent everybody the birth control it wants everybody to have, there's no case. But because in this country, we always bring the private actor in. We'll see this in the Croson case, the affirmative action contracting case as well, where the private actor is, as it were, deputized to enact a state policy. And these cases are just recipes for this distinctly American mixture of considerations, where it's a very important policy goal, and the actor, in this case, has, we're going to assume, sincere religious objections to being the one to enact it. All right. The Hobby Lobby case. So here we are. This is what's called a closely held corporation. This isn't a large publicly traded corporation like, Exxon or General Motors. This is, I think it's pretty much the case. It's a family corporation. They employ a lot of people. I think as many as 21,000 people, but it's a closely held corporation of friends and families. And the reason we're going to just assume that, and certainly there are such cases, they all have certain very strongly held religious beliefs. Okay, they are required under the Affordable Care Act to provide to their employees certain forms of birth control that they believe their religion tells them is a form of infanticide, preventing the fertilization or what's the word, degrading the fertilized egg after fertilization. They are in turn engaging in a practice that on their view is essentially like a kind of infanticide. And here's where Scalia's point earlier of some angels speaking to you in your backyard, there are sacred texts buried on the nearby mountain. It's the silliness or the implausibility is irrelevant always in a religious context. What we're gonna, a religious belief? Really? That's what we're going to do? We're going to tell somebody that their religious belief is wrong, irrational, silly, nonsensical? No, we're not going to do it. Scalia knows that's not going to happen. That's a bad road to go down. This is one of those rare places where liberals and conservatives are really like this. Doing, really? You expect us to take a religious belief like that seriously? No, that's not going to happen. So don't get stuck on your own judgment. I was going to say feelings, but I want a stronger word. Whatever you think is in fact the plausibility of this view, don't get stuck on that. We're in a religious free exercise context here, baby. And it's like we don't assess whether Jesus Christ really is in that wafer. That's not the way we go when we're thinking about protecting these views. We just don't do that. So they have this view. Everybody's respectful of the view. And they say, we want to provide these control. It's not what we want. It's against our religion to give people this birth control. Now, because the Smith case has been essentially overturned because Congress passed the Religious Freedom Restoration Act, what does the court do? They have to ask, okay, what's the government's purpose? They want to provide women with, health care, and they want to make it to have contraception and avoid the agony of wondering about whether to have an abortion. They got a million great purposes. Nobody's going to deny that either. It's like, but do I have to be part of this? The religious guy is saying, can't the government just send these women the birth control directly? Why do I have to be involved? And if you understand the word could, how can they lose? That's all they have to say. That's all the court has to find, saying, yeah, it doesn't have to be you. Could the government do whatever it wants here, which is get this birth control to these women without having you do it, you Mr. Religious Believer? And the answer is, well, of course they could. What, you never heard of the post office? Or, there's no other way. It has to be this guy with these beliefs handing her the birth control pill. I mean, of course, I'm exaggerating, but that's essentially it. That's how they see it. And that is how the case is argued. I mean, they want to argue, the government argues, well, as an employer, they really can't get out of these general requirements that employers have. A corporation was extended First Amendment rights from the standpoint of religious free exercise. And a lot of people went, oh my God, what? Corporations are people? And, this is a typical rallying cry of some on some parts of the spectrum here. But that's, in fact, in this case, I think, it's hard to resist. If I have religious free exercise rights and me and my brother both have them, and we're both Mormons, and we employ people, but the company is just the two of us. To see why in this kind of case, the mere fact that I'm an employer hardly stops me from finding my religious beliefs implicated or asking me to do as an employer. That's fine. Now we go to strict scrutiny. And now the government just has to say, yeah, I know, it's too bad. I wish it weren't this way. But, I got a compelling purpose, and I can't give you an exemption and still satisfy that purpose. Well, unsurprisingly, the state, in this case, the federal government, the Affordable Care Act, the Obama administration, they can easily show that they have a great purpose. It's not the issue, but it's very hard to show the second, that it's got to be you, Mr. and Mrs. Religious Believer, that give the birth control to these people that we want to see get it. And the court can say, essentially, I don't get it. Why does it have to be them? Carve out an exception. You find some other way to get this stuff to them. And they do. That's what has to happen. So just what Scalia said would happen, happened. Perfectly good laws get subjected to this test and fail it, because for every law that says you got to do X and you shouldn't do Y, there's a religion that says you shouldn't do X and you got to do Y. And you're going to create anarchy in this country. That's a bit extreme. But to me, it's one of these marvelous ironies. Scalia was rightly, and I was around when the Smith case was decided, just excoriated by the liberals after the Smith case. Like, what? You won't protect these adorable, Native Americans who want to just ingest the peyote and so on? Ugh, bad guy. And then after the Hobby Lobby case, it's like this voice of prophecy. Oh my God, by extending religious protection in this aggressive way. I mean, it wasn't via the courts. It was because the Congress also disliked what Scalia did so much. And in this sense, you see how, in a way, conservative and liberals can have common cause. I mean, it's because Congress wanted to show there's so much pandering to certain religious groups. There's a lot of pandering to, the Orthodox Jews in the state of New York. We could look at the Kiryas Joel case if you want. There's, pandering to evangelicals in other states. It was like a win-win for a lot of people to agree. Let's show the religious believers we're on their side. This Smith case is not going to stand. We're going to override it with this Religious Freedom Restoration Act. And they did. And now, and then you combine that with this other fact about how things are done in this country, where we're always, as I say, deputizing private actors to enact government policy. If the Obama administration or any administration had just simply provided the health care directly, no case. But because we ask these private individuals to do it, and some of them will have these religious beliefs, and then they get to get the law assessed against strict scrutiny. And with that almost always fatal second part, is there some way to get what you want consistent with carving out the exemption? Are you in fact pursuing it by the most narrowly tailored means possible? Possible. Is it possible that you could get what you want and give these guys an exemption? That's a tough test to beat if it's interpreted aggressively, as I am in my rhetorical flourishes. So there we are. That's where religious free exercise is right now. Strict scrutiny is mandated by congressional act, and that means the religious believer can always say to the state, and by the state I mean either the state of Oregon or the United States of America and the Affordable Care Act, just, can't you leave me out of this? Why do I have to do this? Can't you do this without me? And that's where the argument is. And it's a mistake to say, oh, it's the conservative, pro-religious nature of the justices. Nothing of the kind. It's the strict scrutiny test. It's the strict scrutiny test, and the fact that in this country we're often asking people to, how can I put it, be the vehicles of delivery for government services, be gummed up or subjected to challenge on these grounds. And that's sort of where we are on that issue. I'll sort of look at this stuff and see if there's any point I want to go into. I didn't spend a lot of time here on the court's decision to find the close corporation worthy of free expression of religion protection. A lot of people think that's unwarranted. I myself don't see this as so extraordinary. As I say, if, me and my brother are, Seventh-day Adventists and we happen to employ a couple of people, I can't see any reason why the court wouldn't reasonably worry about whether or not we're being asked to suppress our religiously motivated conduct. And once again, if Scalia had prevailed in Smith, it would have been no problem. These laws would never have been subjected to strict scrutiny. But because his decision sparked such an outcry and a congressional pushback, this is where we are on this issue. All right, I think I'll stop here. Please do look at all these cases and think about these videos. Write me with any questions. I did get one question from one of you about the Sherbert case and fraud. I mean to address it. About the Smith and Hobby Lobby cases. Write me any questions you have. We'll do another sum up and we'll move on to what's called the establishment cases, the religious law in this country, or the worries in this country have two parts. On one hand, you must not be prohibited from the free exercise of your religion. And on the other, we worry about the state, whatever that might mean, supporting religion. The expression is establishing a religion, but that's been taken to mean having an inappropriate relationship of support or endorsement of a religion, or even of all religions as opposed to no religion at all. That's what goes on in the school prayer cases. Even if you're going to pray to the God of your choice, those who don't believe in any God, this is a violation of the constitutional requirement that the state not endorse any position on the religious whatsoever. I don't think we're going to do the school prayer cases. The establishment cases in this country that are very hot, and rightly so, are all about money. And whether the state can have programs which inevitably benefit, quote, private, which in this country are overwhelmingly religious schools. And these are tough and very interesting cases. We'll look at those next. But again, look at these videos. I'll try and send out some notes that you can read on these cases. And again, ask me any questions. Maybe we'll even try and set up some sort of Zoom thing and just live with the way in which not everybody can go. That's it for now. Hope you enjoyed it. Bye-bye.